Now we have the speech of Professor Alessandro del Ninno. Alessandro del Ninno is a professor at US University, and is very, let's say, is very skilled in some way in the application of laws to GNSS in some way, and in particular in space in general, I see. So we'll introduce about the privacy of privacy.
Privacy. I choose the correct definition, which is data protection.
Perfect.
Good afternoon. First of all, I would like to thank you, SOGEI, for this new invitation this year in person of Mr. Knarza, and thank you to Anna Scafuri, Roberto Capua, Antonio Bottaro, and the excellent organizer, Mr. Ionni. Last year, I discussed a paper about legal liabilities in providing GNSS location-based services. But year by year, the task is harder and harder, because now I am going to share with you some remarks about the major issue, which is data protection and privacy. Just to start with, I'm not only a professor, I'm a lawyer, unfortunately for all of you, so I'm going to bring the legal perspective in providing, in a digital market, location-based services. Just to move on, some data, just to frame the discussion. I have outlined the three different elements. One is related to Earth observation that, as you may know, does not imply any privacy concerns. But this is a quantitative information that leads us to understand the capabilities in data collecting of the new technologies. From data coming from Earth observation operation over the next 3 years will be larger than the total collected by the European Space Agency in the last 30 years. The second element, smartphones and in general receivers and devices. Smartphones are the most popular platform to access location-based services, and the general public is willing to trade the data ownership and their privacy in exchange of always-on functionalities location-based service. Let me recall a very brilliant definition given some years ago by the former European Competition Commissioner, Mrs. Kroes, who said that personal data are the digital money of these centuries. It's exactly a definition, because which is privacy today? Don't think about privacy. This is a cultural limitation, such as the right to make ourselves a Robinson Crusoe in the information society where we now live. Now, the legal concept of data protection is the granting of the control to the data subject, which is the individual, the natural person, to whom the personal data are referred. Smartphone, for the first time this year, in 2016, smartphone users worldwide will surpass 2 billion. And by 2018, for the first time in the telecommunication world, the holders of smartphones shall be higher as a number than the holders of features phones. Features phones, let's say the old mobile phones. And the third information, just to frame the discussion, is that by the end of 2014, there were an estimated 3.6 billion of GNSS receivers, which number is expected to rapidly grow in these years to 7 billion. So, according to the big data collecting, it is clear that we need a reliable data protection legal framework, an organic one, and this is not only a legal issue, it is a key factor for the success in the digital market of the GNSS location-based services. And which is the European perspective, which is the position where we are going in the European Union to protect the personal data. First of all, I think, in these slides I have outlined, I think that there are three main perspectives in which we have to evaluate the data protection of the users. The first is that the first data processor is the owner, is the holder of the infrastructure, of the satellite infrastructure, things, for example, to Galileo. So the European Union, the Commission as such, is a data controller. The data controller is the subject who can take decision about the data processing, about the security, and about the purposes of the processing. The second perspective is the private one. Providers of location-based service, the telecommunication operator as a general category, and the third perspective is the third part, private or public, to whom the personal data are communicated or put at the disposal. So when we talk about data protection, the user must be protected by the public owner of the infrastructure, by the private providers of the services, and towards third parties, anyhow processing his or her data. And which is the perception of the European citizens? In these slides I have outlined an interesting recent outcome from the survey conducted by Eurobarometer by the UN Commission in June 2015. The 67% of the European citizens do not trust or do not think to have a complete control, this is the privacy concept, to not have the complete control on the information gathered. The 63 or 62% do not trust the service providers, the telecommunication operators, but above all, the 89% of the European citizens think that they need an overall, organic, and same level of protection of their personal data, regardless the country in which the authority or the private company is processing the data. Which are the technical problems? When we talk about, especially in the location in based services, when we talk about the technical issues which worry the user, we can say that data processing may turn into a continuous surveillance because the technology and the data processing may be hidden, may be intrusive, may be indiscriminate, may be continuous. And the privacy concern may result in the so-called mission creep or function creep, meaning an overall collecting of personal data. There is the problem of tracking. There is the proliferation of the technology and of the receivers due to lowering in the cost of production. So let's come to the $1 million question. Is there a comprehensive, organic, and reliable data protection legal framework at a European level suitable for assessing all the privacy issues and concerns related to the protection of privacy within the GNSS location-based services? I go away and I shall not give any answer. No, joking. My opinion is that we do not have an organic legal framework in terms of unique legislative text, but we have an organic data protection legal framework if we build up taking the various rules from different legislative texts. And this is the perspective now, even in light of the recent adoption of the proposal of new general data protection regulation I shall discuss later on. But in these slides I have summarized the main privacy rules applicable to GNSS. First, do you remember I have discussed about the public perspective, the holder of the infrastructure, of the satellite infrastructure, the European Union. The European Union must protect the user's privacy according to the Regulation 45 of 2001. Then there is the regulation without number because it's a proposal, definitively approved in the definitive text in December 2015, which is the real news I will discuss later, and which apply also to public authorities other than the European institution, but it's important in the provider's perspective and in the private market. Then there is the directive, the so-called e-privacy directive 2002-58, which is the directive focusing on the technical and technologies aspects of the market and of the data processing within the new technology. And then there is the opinion released by the working group. The working group is the body collecting all the national supervisory data protection authorities. It's a European board different from the European Data Protection Authority. This body enacts opinions, and amongst the opinions released during the years, this is very important for our issues because it's named Opinion on Geolocation Services on Smart Mobile Devices, adopted by the Working Party in 2011. So there is an old set of rules considering the growing of the technology, but it is a reference legislative text to be taken into account when engineering the services. Going rapidly, just some remark about the regulation applicable to the institution, European institution, body and agencies. So also the highest public authority, let's say the holder of the Galileo, must grant the right to privacy with respect to the processing of personal data. This regulation is a sectorial one, just applicable to European institutions and agencies, so not to the government, to the national governments, which has to comply with the new regulation. I don't want to be a lawyer, but some definition is needed because these definitions are identical in all the legislative text I have listed before. Personal data. Personal data, any information relating to an identified or identified natural person, being an identifiable person, a person who can be identified directly or indirectly, in particular by reference to an identification number, blah, blah, blah. Just translate from the legalese, I say in Italian, into Italian. If I ask you, in your opinion, what is a personal data, you immediately think about anaggraphic data, about other kind of data. But the personal data subject to the law privacy rules are, for example, the images, a location, my movement, a unique MAC address, an IP, an internet IP address, an email, my biometric data, and so on. All this kind of information which may be collected by receivers or by other devices are personal data. What does it mean processing personal data? Any kind of human operation having as object personal data is a processing falling under the scope of the law. There is an example of listing: collection, recording, organization, storage, adaptation, blah, blah, blah. In the Italian Code on Privacy, there is also the consultation of personal data, such as data processing falling within the scope of the law, which is a personal data filing system, any structured set of personal data which are accessible according to specific criteria, archives and databases, whether centralized, decentralized, base station, or dispersed on a functional or geographical basis. The controller, the subject having the authority to take decision about purposes of the data processing, is the institution of the European Union, including any kind of body. For example, the GNSS is an agency falling under the scope of this regulation. The processor is an intermediate figure, which can be an entity or a person, processing the data on behalf of the data controller. Which are the lawfulness in the data processing? Data must be processed fairly and lawfully, collected for specified, explicit and legitimate purposes. The data processing must be adequate, proportionate, not exceeding the purposes pursued, accurate and where necessary updated, keep up to date, and kept in a form which permits identification of data subjects for no longer than is necessary. This should lead us to the actual issue of the right to be forgotten in the electronic communication networks. There has been last year a very important about Google ruling by the European Court of Justice related to the so-called right to oblivion, the right to be forgotten. But we have no time to go in depth. Personal data by the European institution may be processed only to perform an institutional task, may be transferred within other European institutions, for example, the Commission and the GSA, may be transferred to private receivers only if the receivers are subject to the European, to the applicable until the entering into force of the new General Data Protection Regulation, applicable Directive of 1995, which is now the European Data Protection Directive. So the data may be transferred from European institutions to private receivers only if in member states subject to the European Data Protection Directive, or may be transferred abroad only if the receiver is in a country which grants an adequate level of protection, which does not mean the United States, for example. Being public authorities, there are several exemptions and derogations to the strict application of the privacy rules. For example, the European institution may process data without consent or without any kind of constraint for investigation of a crime. Let's think about terrorism, for economic or financial interests of a member states or of the European Union itself, to protect data subject, for example, the rescue services, for national security, and so on. Security is a major issue requested even to the highest level of public authority, European public authority processing data. All the community institutions and bodies shall take appropriate technical and organizational measures to safeguard the secure use of telecommunication networks and terminal equipment. Measures shall ensure a level of security appropriate to the risk presented. Okay, let's go to the core, to the heart of the discussion, the new General Data Protection Regulation. In December 2015, the European Commission, the European Parliament and the European Council concluded the so-called trilogue, or trilogue, I don't know the correct pronunciation. Trilogue is a sort of consultation between these three institutional bodies, and they reached an agreement about the definitive text of this regulation. This regulation shall be voted in March, in 2 months, without any kind of amendment possible, for the final approval, and then between April and May it shall be published in the European Official Gazette, and from the publication there is a sunrise period of 2 years, so there is no immediate entering into force of the general regulation. The private and public data controller shall have a period of 2 years to adapt even, I will discuss later, the commercial strategies, because this regulation is not a bureaucratic one, is not a text of which a lawyer is happy to discuss. It's a regulation which affects directly the engineering of location-based services and of the related products and services and technology, affects the organization of the providers, affects the commercial projects in the next years. As I said before, only the European institutions, in the perspective of holding the satellite infrastructure, are not falling within the scope of the regulation. All the other private and public authorities do. In this slide, the territorial scope is really interesting because in the legal perspective, the application is not only for the European providers, because the regulation shall apply, because it has to enter into force, to the processing of personal data in the context of the activities of an establishment of a controller in the Union, regardless whether the processing takes place in the Union or not. We are facing the territory in the nowadays information technology world. It's an old concept. So the rules must adapt not only to the growing and to the technology development, but even to the culture, to the development of the concept of law. The regulation shall apply to the processing of personal data of subjects who are in the Union by a controller not established in the Union where processing activities are related to the offering of goods or service. The US provider, if I am a European final receiver of the service, shall have to comply with the principle included in the regulation. The monitoring of their behavior, not only the offering of goods or services, but even the profiling. Scusami un attimo che devo andare indietro. Dov'è qua? Okay, grazie. Not to repeat the main definition, but just to outline that in the new regulation, the formal definition now includes also the location data or the online identifier. Includes new definitions which are very important. Profiling. It's the first time that in a privacy legislative text we find the definition of profiling, which is one of the most sensitive data processing. Any form of automated processing of personal data consisting of using those data to evaluate certain personal aspects relating to a natural person, in particular to analyze or to predict, let's think about the predictive attitude of the big data, aspects concerning that natural person's performance at work, blah, 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 and to analyze the location or movements. So profiling directly affects our location-based services. Pseudonymization, it's a security measure to be engineered in the product and in the services, means the processing of personal data in such a way that the data can no longer be attributed to a specific data subject without the use of additional information. Personal data breach, the producer of hardware or of the receiver or the holder of electronic communication networks must notify, this is a mandatory obligation in force starting from 2013 because there is another regulation, the data breach notification number 513 of 2013, but the general regulation include and always a still applicable mandatory fulfillment. A breach of security, personal data breach, is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure or access to personal data transmitted, stored, or otherwise processed. Controller, we have already said about, I have outlined and highlighted the public authority. Definition and boring legal aspect finished. Now I have taken the principles, the data protection principles from the new regulation. The first one, really important, affecting the commercial strategy, is the privacy by design. A fundamental element, meaning that data protection safeguards will be built into product and service from the earliest stage of development. Meaning, for example, a concrete example, as you may know, from March 2018, the manufacturers of vehicles sold in the European Union shall be equipped, we hope that the emission shall be lawful, but this is another discussion, shall be equipped with an in-vehicle GNSS-based equal device connecting to Galileo in case of accident. Mean privacy by design. Vehicles equipped with system will not be subject to constant tracking, and the data on the location of the vehicle will be continuously erased. First, design, privacy design. The equal system remains dormant until aid or manually activated by the user or automatically activated in case of accident. And no tracking or transmission of data shall take place during the normal operation of the system, nor will any data on the movement on the location shall be communicated to third parties without the specific consent of the vehicle owner. This is privacy by design, a legal principle applied to the market. Another principle, privacy by default, meaning that a privacy-friendly default setting shall be the rule. For example, location setting switched off. It shall be the user to activate. Very important, the regulation forces all the public and private data controllers to assess the privacy before engineering the product or the service, in reality before starting any kind of data processing. When there is a high risk for the data protection of the user, a data protection impact assessment in writing shall have been drafted. Where a data processing impact assessment indicates that processing operation involve a high risk which the controller cannot mitigate by appropriate measure in terms of available technology and cost of implementation, there shall be the mandatory consultation with the national supervising authority, with the data protection authority. I move on. The slides explain the contents of the impact data protection assessment. What must be described, a systematic description of the purpose of the processing, the proportionality, the risk, the measures taken, and the controller, in that case of high risk, must consult the authority, which may assign an 8-week term if the authority shall consider still risky after having evaluated the document assessing the privacy concerns, shall assign 8 weeks to the data controller, which could be a provider, a manufacturer of receivers, or an holder of a particular electronic communication service, shall assign 8 weeks terms to comply. At the very end, it will be possible that the supervisory authority block, it is a power, the data processing and so the commercial project. Another principle, data security. Obviously, I think that the remarkable colleagues, panelists, shall discuss later. But the overall need of security is, by the European legislator, listed in an exemplificative listing. Pseudonymization and encryption are sufficient security measure. The ability to ensure the ongoing confidentiality, integrity, availability and resilience of the system and services processing the personal data. The ability to restore. The periodical evaluation of the data, the security measures applied to the product or to the service, let's say to the data processing. Personal data breach, another mandatory privacy fulfillment. Any data controller shall have to notify to the data protection authority, the national data protection authority, within 3 days an occurred data breach in the system. An organizational principle which affects specifically the providers of GNSS location-based services. The appointment of a specific data protection officer within the organization. When? It's not always mandatory, but for example, when the core activities of the controller consist of processing operations, which by virtue of their nature, their scope, or their purposes, require regular and systematic monitoring of data subjects on a large scale. So this is the case. A data protection officer is a skilled person who can be an employee, may be an external consultant with a regular agreement, but is a mandatory role in the companies to be appointed when the regulation shall enter into force in specific cases, like the one I have discussed. The regulation, when I say before, there is no organic, there is no unique legislative text. The same regulation, which is the new legal framework in data protection, refer Article 89 to the Privacy Directive as the legislative text which shall continue to be being applicable to the new technology. So not only the regulation, but we have to face in regulating from a legal perspective the location-based services. Also, we have to deal also with the e-privacy directive, which is recalled by the last, and I am going to conclude, which is recalled in the opinion, so I directly discuss about the e-privacy directive and about the opinion, released by the working party. These are the specific rules for location-based services. even if obviously the regulation shall imply the need to update all the legislative text, obviously. The objective of the opinion is to clarify the legal framework applicable to geolocation services available by smartphone, which can connect with the internet and are equipped with location-sensitive sensors such as GPS. Obviously, the European Working Party take into account the GPS. But the opinion also deals with the main three types of infrastructure used to provide the geolocation services, meaning GPS, the base station, and the Wi-Fi. In particular, this opinion, in 2011 it was a perspective, now is focused on the location-based services which are based on a combination base station, GPS, and Wi-Fi data. So, which are the rules? First of all, the Privacy Directive and the related rules which I summarized in the last slides. The Privacy Directive only applies to the processing of base station data by public electronic communication services and networks, so by the telecom operators, and only with reference to location data, and there is the definition, any data processed indicating the geographic position of the terminal equipment of a user, and only to the combination of the unique MAC address and the calculated position of a Wi-Fi access point. For the rest, now the European Data Protection Directive, in the near future the General Data Protection Regulation, shall apply. So, not only the lawyers, but the operators shall have to construct, to build, taking the principle from the regulation, taking from the e-privacy directive the rules, taking from opinion like this opinion the specific execution rules, which is a little bit difficult, especially when we talk about new technologies. What is said by the opinion? First of all, there are three data controllers, each of them bound to comply with the privacy constraints set forth in the opinion. The controllers of geolocation infrastructures, the providers of geolocation applications and services, and the developers of the operating system of smart mobile devices. So, dear Roberto, you are a developer. Okay. Which is the legitimate ground for the data processing? It is the consent, obviously. But let me add a clarification. There is a cultural limit in our country, but also at the European level. We consider the privacy like a sort of overall prohibition of data processing. It is not a correct position. All the legislative text related to data protection balance two fundamental rights, the data protection and the free movement of the information. All the legislative texts are construed as a continuous balance between protection and free movement of information. So when, especially in our country, someone says there is the privacy, it's not allowed, it's false. Balancing, for example, the legitimate ground, so there is no need for a specific user consent. For example, because location data from smart mobile devices reveal intimate, it's the consent, okay. The consent, there is another slide. The consent cannot be obtained by general terms and conditions, must be specific, clear, informed consent. The consent must be specific for any purpose of the processing. I track your location, but if I want to profile you, if I track your location by means of a service, consent is not necessary because I am providing to you a contractual services, and the law provides that when the data processing is necessary to perform a contract, the user consent, the data subject consent is not necessary. But if beyond this contractual purpose I further want to profile you, now the consent is necessary to be acquired. Just in 2011, the working parties say that the location services must be switched off as privacy by default. So it is said in 2011. The working party recommends limiting the scope of the term of time. I do not sign an agreement with the devil for the eternity. Sufficient grant granularity. Granularity means acquiring consent for each purpose. With regard to the position of location data, consent to be located in a wide area of 1 kilometer or 1 meter, two different consents. Mapping of Wi-Fi access point, and just 2 minutes and I'm going to conclude. This is the slides I was referring before about the legitimate ground in place of the user's consent. For example, mapping Wi-Fi access point, companies can have a legitimate interest, overcoming the consent, in the necessary collection and processing of the MAC addresses and calculate the location of Wi-Fi access points for the specific purpose of offering geolocation service. This is the main technical fulfillment, so there is no consent needed. But the balance of interest in the perspective of the user is that the user may also have an opt-out from the database without the provider demanding any additional personal data. The information notice. We all know that the consent must be informed. Informed how? It must be based on a prior information notice. Prior information notice means prior the starting of the data processing. And it's important that the working party recall that the information must be clear, comprehensive, understandable, non-technical. And the validity of the consent is linked to the quality of the information given by the provider. For example, a consent even given but not based on an information clear, it's void. Retention, the working party suggests to exploit location data retention period which are not eternal. And regarding the MAC address, there is a specific regulation. Let's see how the specific technical and legal rules are set forth in different legislative text. The opinions say the enforcement rule that the unique identification number may only be stored for a maximum period of 24 hours for operational purposes. And the final slide is obviously the data subject right. The provision of service must always be based on the complete fulfillment and compliance of the exercise of the data protection right by the user. So the procedure to exercise this right, to rectify, to delete, to revoke the consent must always be granted. Sorry for having taken more times, but as you maybe, I hope, understand, it is a very difficult forest of law rules, technical, legal, legislative text, and building in 40 minutes an attempt of clarity, it has not been very easy. Thank you for the attention.
Thank you, Mr. Del Ninno. It was very interesting to see such point of view. So legal, it's important for any application, the legal point of view. Now we have the speech of Mr. Pozzobon. See, we have the coffee break before that, so we can relax a bit.